Committee on Oversight and Government Reform will come to order, and without objection, the Chair is authorized to declare a recess at any time. Appreciate you being here on this important topic, transparency at the TSA. Today, the committee will explore the lack of transparency at the Transportation Security Administration. We will hear testimony from the Office of Special Counsel, often known as the OSC, and the Department of Homeland Security's Inspector General about problems they're having with the TSA. Congress created the Office of Special Counsel to investigate and prosecute violations of prohibited personnel practices, especially whistleblowing. In order for the OSC to complete its mission, agencies are required to produce complete and unredacted documents to the Office of Special Counsel. Unfortunately, the TSA is not fulfilling their legal obligation to produce documents, frustrating OSC's investigative efforts. And I can tell you with a passion on both sides of this aisle, it is not acceptable to withhold information. It is something we have both committed to on both sides of the aisle to help protect and ensure that whistleblowers are protected. You have a right in this government as a government employee to blow the whistle. But when the TSA withholds documents and does not allow the OSC to do its job, that's wholly unacceptable. Former TSA Administrator Peter Neffinger testified before the committee last May that the TSA would base its response to allegations of whistleblower retaliation on OSC's findings. But now TSA is withholding the documents OSC needs to complete its investigation. So on one hand, you have the TSA Administrator saying, oh, we're going to base our conclusions on the findings of OSC, but the TSA won't give all the information to the OSC. Today, I do not want to hear about how voluminous the documents are. I don't want to hear about how many you've given them. There is but one metric that is important to me, and that is the percentage. If you dare go to the place to tell us about how many documents you've turned over, every time you do so, we will ask you what percentage of the documents did you actually turn over. TSA is one of the agencies in most need of the OSC's work. Since 2012, the OSC received approximately 243 cases from TSA employees alleging retaliation for blowing the whistle. A lot happens, very few blow the whistle, but when they blow the whistle, to have 243 people say that there was retaliation is a number that is a flashing red light and scares us. The committee is constantly hearing how complaints from TSA employees about how the agency is a hostile work environment for whistleblowers. It has been almost a year since our last hearing on the mismanagement at the agency. It's disheartening that we find ourselves here again. It's frustrating and it shouldn't happen. TSA selectively withholds information from OSC by asserting a common law attorney-client privilege that does not apply to interagency disputes. TSA's chief counsel, Francine Kerner, the agency's chief counsel since the agency's inception more than 15 years ago, could not identify the client holding the privilege. When pressed, Kerner informed the staff that, quote, TSA has no legal obligation to turn over documents to the OSC, end quote. Kerner's inability as chief counsel to articulate who she represents and her withholding of information shows a fundamental misunderstanding and antagonism towards the OSC's function. Interestingly, the TSA later sent the committee a letter stating, quote, TSA recognizes its legal obligation to provide documents to the OSC and does so regularly, end quote. In fact, I'd ask unanimous consent to enter that letter into the record. It was sent to us on March 4th without objection, so ordered. It was sent to us March 1st, 2017. It's not about doing it regularly, it's about doing it always. And that is something that drives us here today. The OSC gets to see all of it, 100% of it. Not a portion of it, not some of it, not just the parts you want them to see. The OSC gets to see all of it. That means 100%. Furthermore, it should not take a congressional hearing for the TSA to acknowledge an existing legal obligation. Similar to the agency's non-cooperation with the OSC, the committee has long criticized the agency's use of sensitive security information, an SSI designation to withhold information. In 2014, the committee issued a bipartisan report, finding that the agency inconsistently and improperly designated certain information as SSI simply to prevent embarrassing information from being made public. But these problems persist. According to the Department of Homeland Security's Inspector General, quote, TSA is abusing its stewardship of the SSI program. None of these redactions will make us safer and simply highlight the inconsistent and arbitrary nature of decisions that TSA cannot be trusted to administer the program in a reasonable manner, end quote. That's about as damning as it gets. That is as direct as it can possibly be. In a recent transcribed interview with the committee, former TSA Deputy Administrator Mark Hatfield told the committee, and I quote, "You could mark a Chinese carryout menu SSI," end quote. Talk about an abuse of the system. A Chinese menu, that was his example. The issue with transparency at TSA tend to have one thing in common, and that's Francine Kerner, the Office of Chief Counsel. She seems to be the conduit and the person that we continually bump into. Kerner has checkered history and has a duty to share information. As a lawyer for the Treasury Department in the early 1990s, she was the subject of an investigation for improperly disclosing confidential information to the White House. Now she's advocating for the TSA to withhold information on alleged whistleblower retaliation from the agency charged to investigate it. There's something fundamentally, totally wrong and backwards about that. Committee will not tolerate these impediments, especially when it comes to protecting whistleblowers and ensuring transparency. The acting administrator is here today. We're requesting today you right this wrong and immediately turn over all information withheld from the OSC and put an end to the practice. We're going to be a very short timeline to do so, and we will follow up. So I'll recognize the ranking member, Mr. Cummings of Maryland.
Thank you very much, Mr. Chairman. And last week, our committee conducted an extraordinary interview at my request with Mark Hatfield, who served as the Deputy Administrator of the TSA and worked at the agency for some 13 years. He explained to the committee that TSA employees lack some of the most basic safeguards to protect them against retaliation when they highlight security concerns. The deputy described an agency where, in the absence of normal federal employee safeguards, a culture of retribution and arbitrary personnel actions evolved that made employees reluctant to raise security concerns. I will highlight some of the statements made by the deputy during his interview, and I ask unanimous consent to include longer excerpts in the hearing record. With respect to the subject of today's hearing, the deputy explained, quote, "There was very little transparency. There was a lot of distrust. There was a sense of, in favor and out of favor employees," end of quote. He explained, quote, "So many things were governed by self-direction at TSA, it bred misbehavior," end of quote. He said the lack of protections for employees, quote, "gave people the opportunity to do things that were typically not against the rules because the rules were so flexible, but very questionable when you looked at it from a moral or ethical point of view," end of quote. During the deputy's interview, our staff asked him if the absence of normal federal employee safeguards contributed to an environment in which employees did not want to come forward with information about security. In response, he said, and again I quote, "Oh yeah, it didn't take long for you to know enough of your compatriots had, taken an arrow in the back and were either wounded or dead, and you had a decision to make depending on how loud you wanted to be or how far you wanted to go," end of quote. The deputy also warned, and I quote, "People learned that if you spoke too loudly, or if you questioned whether the emperor was actually wearing clothes or not, that you could do it at, personal consequence," end of quote. When Congress created the TSA in 2001, it did not provide the agency's employees with all of the due process protections given to other federal employees under Title V. The deputy said that although some flexibility might have been appropriate, that TSA was first created, the agency, and I quote, should have started converting some of these practices to make them more standardized in federal government practices, end of quote. He explained, quote, the structure that gave it the flexibility and the facility and the power to make extraordinary moves it did when it was created should have evolved, and unfortunately, some of them have just led to toxicity rather than a healthy agency, end of quote. One tactic reportedly used against TSA employees was, quote, directed reassignments, end of quote, or forcing employees to move entirely to entirely new locations as punishment for raising concerns. I got to tell you, this is something that really bothered me because, and I'm sure it did the chairman, because we had people who were being divided from their families, one person going maybe to Connecticut and the other one going to Florida. Give me a break. And it was punishment. Punishment. For example, the deputy explained that the former assistant administrator in charge of the agency's security operations ran a, quote, very dictatorial department, end of quote. Rather than focusing on improving security, he was, quote, using the directed reassignment process to manipulate positions in the field and to both help people that were in favor and to punish people that were out of favor, end of quote. The deputy confirmed during his interview that one TSA whistleblower, Jay Brainerd, who testified before this committee on April 27, 2016, received a directed reassignment after being, quote, very outspoken, end of quote, about security concerns. According to Deputy Brainerd, quote, would often raise issues, end of quote, about security, including, quote, the extraordinary emphasis on speed over quality of screening, end of quote. The deputy said that this whistleblower highlighted, quote, what many felt was unreasonable reliance on a metric system that was oftentimes beautiful in full-color presentation on slide decks, but was very detached from the reality of the front line where the actions were taking place, end of quote. The deputy also confirmed what we have heard many times before, that TSA has abused the SSI designation to cover up information. He joked that in the early years of the agency, quote, you could mark, and I think the chairman referred to this, you could mark a Chinese carry-out menu SSI, end of quote. He added, quote, a brochure or something that was clearly public, consumable material or information you could get on the internet or in the library, and they would, stamp it SSI, end of quote. Now, from everything we have seen, TSA operations have improved over the last 2 years under most recent administrator, Vice Admiral Peter Neffinger. But the deputy's interview last week makes crystal clear that TSA employees need the same protections as other federal employees so they can speak up about the security of the American people without being retaliated against. And Congress can consider these reforms. And let me say to the chairman, I thank you again, and I thank all of our members for standing up for whistleblowers. Ladies and gentlemen, if we don't stand up for whistleblowers, we don't need to be here. We need to go and get another job, because as far as I'm concerned, it would be legislative and congressional malpractice not to do so. Some of the best information that we have gotten from whistleblowers, and we must do everything in our power at all times to protect them. And on the other hand, for anyone who thinks Congress should receive Title V protection for employees at other federal agencies, TSA is a case study demonstrating why this would be a terrible idea. And with that, Mr. Chairman, I yield back. I also noticed that Congressman Sarbanes just came in, and he's one of our newest members. Thank you.
Welcome. Thank you. Glad you're here. Members are advised that we do anticipate votes on the floor. We're going to get through hopefully get through all of the opening statements, but at the appropriate time we will break. The intention is to allow the votes on the floor, and then we'll come back and finish up the hearing. We'll hold the record open for 5 legislative days for any members who'd like to submit a written statement, but let's now recognize our panel. We're pleased to welcome Ms. Gawadia. She's the Acting Administrator for the Transportation Security Administration. The Honorable John Roth, Inspector General for the United States Department of Homeland Security, and the Honorable Carolyn Lerner, a Special Counsel for the Office of Special Counsel, Special Counsel for the United States Office of Special Counsel. We welcome you all. Pursuant to committee rules, you are to be sworn before you testify. So if you will please rise and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated and let the record reflect that all the witnesses answered in the affirmative. We would appreciate it if you would limit your oral testimony to 5 minutes. We'll give you a little bit of latitude, but of course your entire written statement will be made part of the record. We'll now recognize the Acting Administrator for 5 minutes. And by the way, you have to straighten it up and get that microphone right up in there. It's a little uncomfortable, but bring it up close. Thank you.
Good morning, Chairman Chaffetz, Ranking Member Cummings, and distinguished members of the committee. Thank you for affording me the opportunity and privilege to speak to you today about information transparency at the Transportation Security Administration. I am indeed fortunate to represent a tremendous workforce that is responsible for executing a critical security mission to protect the nation's transportation systems. Vital to that mission's success is how we share information with our many transportation security partners. The dynamic and increasingly complex threat environment in which we operate demands that TSA and our partners share information in a timely and secure manner. To that end, we work closely across the spectrum of transportation modes to exchange information, solicit feedback, and develop policy and guidelines. Indeed, our recent cooperative initiatives with industry stakeholders have yielded significant improvements to our security operations. For instance, we collaborated with airports and air carriers to address the surge in passenger volumes last spring and summer. And in the process, we established our Airport Operations Center as a permanent and direct communication channel. Leveraging the center, TSA continues to hold daily calls with airlines and airports to track screening operations. We also communicate regularly with the traveling public through a variety of outreach efforts, press releases, and social media. TSA Cares and at Ask TSA are 2 of our most popular and successful models of passenger engagement. But the transportation security system does not stop at our borders. It is undeniably global in nature. That is why TSA works alongside partners and plays a leading role in a number of regional and international organizations with a common vision for transportation security. Across all our interactions, TSA strives to be transparent and forthright. In point of fact, doing so serves our interest, as the free and frequent exchange of information to and from partners helps us make better informed decisions and build lasting trust. However, we also must remain absolutely vigilant in safeguarding against the release of sensitive information, which could cause harm if disclosed to our adversaries. We must balance the transparent flow of information with our serious responsibility to prevent that information from falling into the wrong hands. For that reason, we ensure that information requiring protection is properly marked, handled, and distributed. Sensitive Security Information, or SSI, is one category of protected information that is defined by statute. Governing departmental and TSA management directives mandate that such information be released to the maximum extent possible without compromising transportation security. And because we count on our greatest resource, our people, to enforce these protections, we have updated SSI training and made it an annual requirement for all TSA employees and contractors. In addition, we have developed a comprehensive SSI policies and procedures handbook, as well as improved reference guides. Keeping with the spirit of transparency and preserving the public's access to appropriate information, TSA also follows established procedures for adjudicating challenges to SSI designations. Taken together, these measures enhance the SSI program and contribute to TSA's overall growth as a true learning organization. We must also continue to learn from each other. I encourage my TSA colleagues to feel empowered in voicing their thoughts, suggestions, and concerns that can lead to improvements in our workplace environment and how we do business. That means creating and sustaining an organizational culture which values responsible challenges to conventional thinking and invites opportunities to get better. And those opportunities can come from a number of sources, be it an audit conducted by the Inspector General or an employee calling attention to an agency impropriety. I want to take this opportunity to thank Mr. Roth and Ms. Lerner for the efforts of their offices. With their help, I do believe we will continue to improve. Let me stress that no matter where the challenge comes from, TSA has zero tolerance for prohibited personnel practices, such as retaliation against whistleblowers. TSA is fortunate to have employees and stakeholders with a shared passion for mission success and integrity. We will continue to work hard to exceed their expectations. In conclusion, I would like to emphasize that each side of the coin, sharing information transparently and protecting information when it is required, is indispensable to our national security mission. I have every confidence that the proud men and women of TSA today are more than up to both tasks. Thank you.
Thank you. Appreciate that. Before we recognize the Inspector General, members are advised we have a vote on the floor. So I'm going to put us into recess, and we will reconvene no sooner than 11 a.m. So you're free to go to the cafeteria, do whatever you want to do. We'll be no sooner than 11, but if you'd please be back here just before 11. And as soon as the votes are done on the floor, we'll reconvene. Committee stands in recess. We only need. Committee on Oversight and Government Reform will come back to order. We appreciate it. We were delayed for a moment, more than a moment, because of votes on the floor, but I believe now we were going to hear testimony from Inspector General Roth. You're now recognized for 5 minutes.
Thank you, Chairman Chaffetz, Ranking Member Cummings, and members of the committee. Thank you for inviting me here today to testify regarding issues relating to TSA. Inspector General oversight of TSA's programs and operations fosters positive change and makes government better. However, the effectiveness of our oversight depends on our ability to issue detailed, balanced, and public reports that accurately describe our findings and include recommendations to resolve them. The Inspector General Act requires that we inform the DHS Secretary, Congress, and the public about any problems and deficiencies we identify through our work. Public scrutiny of what we find is key to accomplishing our mission. We have found that TSA has a history of taking an aggressive approach to restricting information from being made public, especially with respect to a category of information known as sensitive security information, commonly known by its acronym as SSI. This problem is well documented. I first encountered the issue in 2015 when TSA insisted on applying the SSI designation to information in an audit report concerning the IT operations at JFK Airport in New York. Similar information had been previously published in 2 prior OIG reports. I appealed the issue directly to the TSA administrator, but it was not resolved to my satisfaction. And sure enough, it was repeated in our latest report on TSA IT systems that was published in December of last year. In that report, TSA again demanded redaction of information that had previously been freely published without objection, and in which my IT security experts have told me poses no threat to aviation security. Entities outside the OIG have made similar findings, and I believe that the problem is deeply rooted and systemic. For instance, as far back as 2005, GAO issued a report finding that TSA did not have adequate policies and procedures to determine what constitutes SSI or who was authorized to make the designation. GAO found that the TSA's lack of internal controls left TSA unable to be assured that they were applying the designation properly. Nearly 10 years later, this committee reached a similar conclusion in a bipartisan staff report it issued in 2014. 2 years after that, in 2016, the chairman of the House Committee on Homeland Security, Subcommittee on Transportation of Security, objected to TSA's management and use of the SSI designation, noting that the improper invocation of SSI, and I quote, raised the specter we've heard again and again about TSA conveniently using the security classifications to avoid having public discussions about certain things that may be unpleasant for them to discuss in public, end quote. In addition to these inconsistent SSI designations, we have encountered instances in which TSA redacted information so widely known that redaction bordered on absurd. For example, TSA redacted, claiming SSI, a statement in one of our draft reports related to expedited screening process. Here's the quote: "Passengers are not required to remove shoes, belts, laptops, liquids, or gels," end quote. We showed TSA that this information is on their publicly available website, and pretty much every traveler who goes through the pre-check lane understands this to be the case. And ultimately, TSA agreed that the information was not in fact SSI and should not have been redacted. While this was appropriately resolved, it takes time away from the audit process and causes unnecessary delay. Likewise, we have other instances in which TSA has attempted to restrict information that we found on their own website. These examples highlight what I believe is the incoherent and inconsistent nature of the program and raise serious concerns in my mind as to whether TSA can be trusted to make reasonable, appropriate, and consistent SSI designations. Under DHS policy, any authorized holder of SSI who believes that a designation is improper may challenge the marking. Unfortunately, as I discovered, this appeals process is structured to ratify TSA's SSI designations and prevent the review of such designations by independent external entities. The appeals process is foreordained and fails to properly balance the public's right to information against non-speculative threats to aviation security and is vulnerable to abuse. We are currently in the fieldwork stage of a comprehensive review of TSA's management of its SSI program and its use of the SSI designation. We expect to have a final report by July 2017 and will provide a copy of this report prior to its publication to this committee. Additionally, we will continue to review and publish public reports on TSA's programs and operations. To the extent that we continue to observe the abuse of SSI designation, we will continue to highlight it. Mr. Chairman, this concludes my testimony. I'm happy to answer any questions you or other members of the committee may have.
Thank you. We'll now go to Ms. Lerner. You're now recognized for 5 minutes. Bring that microphone up nice and close. There you go. Thank you.
Got it.
Thank you.
Chairman Chaffetz, Ranking Member Cummings, and members of the committee, thank you for the opportunity to testify today about the U.S. Office of Special Counsel and our investigations of whistleblower retaliation at the Transportation Security Administration. I appreciate the committee's commitment to oversight, including strengthening OSC's ability to carry out our good government mission. I want to take the opportunity to thank this committee for your leadership in passing the Thoroughly Investigating Retaliation Against Whistleblowers Act, H.R. 69, during the opening week of this Congress. That legislation will help OSC conduct our investigations at TSA and other agencies. During our investigations, it is standard to issue document requests and interview witnesses. A full and complete investigation requires access to all relevant information. Although agencies generally cooperate with OSC's requests, some do not. Some withhold documents and other information by asserting common law privileges, and in particular, the attorney-client privilege. As the committee knows, the attorney-client privilege protects certain communications between a lawyer and client. The privilege allows a client to disclose confidential communications in order to promote frank and candid discussions. As someone who spent 2 decades practicing law in the private sector, I understand the importance of the privilege, and of course, it helped me to represent my clients. In government, the privilege is certainly important in certain contexts, such as in litigation with third parties. Having said that, there is simply no basis for federal agencies to assert the attorney-client privilege during an OSC investigation. This is not litigation. This is an internal administrative investigation that OSC is conducting for the government. Indeed, no court has ever held that the attorney-client privilege can be used during an administrative investigation between 2 government agencies. This makes sense. We all work for the same government. Congress, and this committee in particular, have made clear that there is a strong public interest in exposing government wrongdoing and upholding merit system principles. Federal agencies may not use privileges to conceal evidence from the agency that Congress has charged with investigating them. Unfortunately, the TSA has been somewhat of an outlier in its aggressive use of attorney-client privilege in several cases. In 2012, Congress extended whistleblower protections to TSA employees through the Whistleblower Protection Enhancement Act. Since then, OSC has received more than 350 retaliation cases from the TSA employees. 2 pairs of companion cases illustrate the challenges OSC faces in getting needed information from the TSA. The complainants are TSA officials who experienced involuntary geographical reassignments, a demotion, and a removal, all allegedly in retaliation for their protected whistleblower disclosures. In these cases, TSA withheld information from its document productions, asserting claims of attorney-client privilege. OSC has asked TSA to withdraw the claims of privilege, but both TSA and DHS rejected these requests. There are several problems with TSA's assertions of privilege. First, as discussed above, shielding information from OSC conflicts with their statutory mandate to investigate the legality of personnel practices. When TSA doesn't disclose the reasons why they took an action against the whistleblower, we can't investigate whether it's retaliation. In addition, TSA's attorney-client privilege review causes significant delays in investigations. In these 4 cases, OSC has spent months waiting for documents while TSA was reviewing responses for privilege. OSC is a tiny agency. We only have about 40 attorneys to investigate hundreds of retaliation cases. Our lawyers are spending too much time negotiating for documents, time that could be much better spent advancing the investigation. These delays also directly impact complainants who are waiting for relief, often when they are facing devastating situations at work. Despite the challenges created by TSA's privilege claims, OSC is committed to completing thorough investigations and protecting TSA employees. Thank you for the opportunity to testify today. We appreciate the committee's interest in these challenges we're facing. I look forward to answering your questions.
Thank you. Appreciate it. We'll now recognize the gentleman from Alabama, Mr. Palmer, for 5 minutes.
Thank you, Mr. Chairman. I believe we have a slide. Ms. Lerner, can you give an example of the kinds of redactions that TSA has provided your office with?
Yes.
Can you put the slide back up?
So this is an example. This is one of the attachments to our written submitted testimony. This is an example of the type of document production that we're getting from TSA. And it's a real problem because this document, we believe, would go directly to the issues that we're trying to investigate in the case. Was there a disclosure by the employee? Were they whistleblowing? And what were the reasons that the agency had for taking the action against the whistleblower after they blew the whistle? And when we get a document that's 100% redacted, there's no way we can get to the bottom of the information that we really need.
Does it appear to you at least that the use of the redaction is selective and inconsistent to the point that it might raise suspicion that it's being used to cover up problems at TSA? Would that be fair?
I can't get to what's motivating them in their
I'm just
reasons
asking
for redacting,
appearances.
but it does raise concerns.
Thank you. Dr. Gawadia, is that how you pronounce that? Thank you. Ms. Lerner provided examples of overly broad redactions by TSA. Were you aware that TSA withheld information from the Office of Special Counsel in this manner?
Yes, sir, I am aware that we do assert attorney-client privilege in some instances.
Can you explain why the documents Ms. Lerner has provided today were redacted?
So I do not know the exact specifics of the case that you have
couldn't
put up.
from reading that
Right.
slide.
Certainly, and we would have to go back into the log and determine the exact nature.
Ms. Lerner stated in her testimony that even the date, author, the recipient of the document were redacted. Can you explain how that information would be privileged?
So again, I don't know the context in which this particular document.
I'm not talking about that particular document. There are other documents. Why would you be redacting the date and the author and the recipient? Can you give an explanation of that?
So I believe it might be on a case-by-case basis, those particular
Selective?
issues. I would not say
Inconsistent?
selective, I would say case-by-case.
Well, it appears to be selective and inconsistent. I mean, again, why would you redact the date?
Again, sir, I have no ability to opine on the document put up or in the generalities. It would have to be answered on a case-by-case basis.
You know, you talked about attorney-client privilege. If there were no attorneys present at the meeting, how could TSA possibly invoke attorney-client privilege with respect to the document?
So again, I do not have insight into the particular document you're talking about.
I'm not talking about that, just that document, but this has gone on with other instances where, in one case, the attorney couldn't even identify the client, yet claimed attorney-client privilege.
So let me go back to the question you asked previously about if the attorney is not in the meeting. It might be that an employee is asking for attorney's advice on something. But again, it's
Well, what if
speculative
the
because
attorney
I
can't
don't.
identify the client?
I'm not sure where that reference is coming from, sir.
I think we'll get into that later. Ms. Lerner, would you like to comment on that?
So I think really what this boils down to is we don't believe that the attorney-client privilege applies in any document, for any document request. We are acting in the agency's shoes. This is an intra-agency, intra-government investigation that Congress has asked us to conduct. It's not appropriate for any agency to claim attorney-client privilege when they're producing documents to OSC. It would be the same thing with an IG or GAO. An agency would never claim attorney-client privilege during an IG investigation. It's not appropriate to claim it during an OSC investigation either.
Well, that's part of my problem with this is, as I said, selective use of redaction, the inconsistent use of it, claiming attorney-client privilege. It, you know, with all due respect, it appears that TSA is trying to cover up problems. Mr. Roth, do you have any comment on that?
We've been very fortunate that DHS has taken the policy since I've been there that the attorney-client privilege does not apply to anything that we receive. Of course, they're a little more restrictive on publication because they don't want to breach the attorney-client privilege for a number of reasons, and that's obviously their decision whether or not to do so. But they have taken the position that attorney-client does not bar us from access to information.
Well, I appreciate your answer, Mr. Chairman. I yield back.
Thank the gentleman. We'll now go to Ms. Demings of Florida for 5 minutes.
Thank you so much, Mr. Chairman, and thank you to all of our witnesses who are here before us today. We do understand and know how important transparency is, but also how important whistleblower protections are to the overall process. I'm pleased today to hear from both sides of the aisle to speak out in support of whistleblowers and the important work done by the Office of Special Counsel. But despite the talk that we've heard, congressional Republicans have failed to provide OSC with the funding that you so desperately need to carry out the work. President Obama's congressional budget justification of the Office of Special Counsel for fiscal year 2017 requested additional funding for the agency, noting a record number of whistleblower disclosures, up 74% over the prior 2 years. Ms. Lerner, is that correct? And has OSC seen an increase in its caseload over the past several years? And do you currently have a backlog in handling whistleblower complaints?
Thank you so much for the question. Yes, our caseload has about doubled during the time that I've been special counsel. We got about over 6,000 complaints last year over all 4 of our program areas, which is a really big increase. Our lawyers are beyond the ability to work cases the way they need to be working them. We do appreciate that the House, in the House's bill, they fully funded us at the President's number. The Senate bill kept us level at last year's levels. We really do need an increase in funds pretty desperately in order for us to fulfill our good government mission and to do the kinds of things that Congress has asked us to do. To be effective, we need appropriate staff, and we don't have it right now.
I understand that according to the fiscal year 2017 budget justification that you requested 15 new full-time employees to meet its caseload. Is that correct?
That's correct.
And even though this increase received bipartisan support in the House, the Republican-led Congress failed to pass the appropriations bill last year, so OSC did not receive the increase in staffing as requested. Is that correct?
That is correct. And also in the Senate bill, they kept us at the same level as last year. They did not follow the House's lead in terms of giving us the number that the President requested.
Okay. And President Trump was instrumental in pressuring Congress to delay action on these spending bills, meaning that current spending levels will remain in place until at least April. Ms. Lerner, have budget constraints affected your ability to enforce whistleblower protections, and if so, in what way?
I think our lawyers are doing an amazing job with the resources that they have. As you noted, we did request additional funds so that we could hire at least 15 more lawyers. As I mentioned in my opening statement, we have about 40 attorneys right now assigned to do the investigation and prosecution of the hundreds of retaliation cases that are coming into our agency. It creates frustration for complainants. It creates delays in terms of getting people the relief that they need. And frankly, our staff is frustrated because they would like to be able to spend appropriate time on the cases. So it would be very, very helpful if our agency were fully funded.
I think you stated in 2012 that you received more than 350 whistleblower retaliation cases from TSA employees. Would you say that's correct?
Yes, that's right.
And how many did you receive last year, roughly?
I don't know the exact number, but it's about on the same level.
And do OCS's resource constraints affect how quickly you can resolve the open cases, the extreme high number of open cases that you currently have?
Yeah, let me give you an example. When I first started as special counsel in 2011, our complaints examining unit had about 25, maybe 30 cases per complaint examiner. Now they are up to 60, sometimes 70 cases per examiner. That's a double, tripling of the caseloads. That means it takes us much longer to determine whether a case should be fully investigated. It takes us longer to get relief for complainants at a time in their life when they're really under terrible, workplace situations. Someone who, may need immediate relief, we may not always be able to get to their case as quickly as we ought to. It's taking around 90 days on average for cases to get through our complaints examining unit. When I first started, it was an average of closer to 30 days.
Thank you so much.
Gentlewoman yields back. I now recognize myself. Ms. Gawadia, you said that TSA has zero tolerance on those that are applying retaliation to whistleblowers, correct?
Yes, sir.
Do you believe that the TSA, so if an employee believes that they have been retaliated against, who is or what organization is the one that comes in to figure out whether or not there has been retaliation?
So employees at TSA are afforded all protections from the Whistleblower Act. All TSA employees are. So they can go up any number of channels. They can go up to the EEOC line, the MSPB line, or the OSC line. They can even...
Okay, so let's take the OSC, for example.
Certainly.
The whistleblower says, I've been retaliated against. The TSA says, no, they haven't. There's a dispute. OSC is one of the organizations, I think the primary organization, to resolve that dispute, correct?
Certainly.
You agree with that?
Yes, sir.
So what percentage of the information should the OSC be able to review in order to figure out the right conclusion?
So the OSC should have all the information they need to figure
To
it out.
define all of the information.
So I appreciate where you're headed with your question on the information we redact for attorney-client privilege issues. In that regard, I have to say we follow departmental guidance.
Wait. There's the law, and then there's departmental guidance. You said you believed that the OSC should get all of the information. What percentage is all?
So I said...
No, it's a simple question.
I hear you.
I want to be clear in what I'm asking. If she is to get all of the information, which you said,
Well, actually...
what percentage is all?
All would be mathematically 100%, but my sentence was all the appropriate information.
Appropriate. So what do you believe the OSC should not see?
Sir, the attorney-client privileged information is presently redacted. I know you don't want to hear numbers, so I'm not going to give you numbers, but it is a very small fraction.
The only number I want to hear from you is that we give the OSC 100% of the information. That's what I want to hear you say. You said you give them all, that they should have all. How are they supposed to come to a proper conclusion when you only give them something short of 100%?
So in this regard, again, I have to stress that TSA is not an agency independent. We belong to a department. We follow guidance that the department gives us. Now, as a part of this hearing, we have this, your concern has been raised. I can assure you that we will follow up with this at the department level, make guidance in writing if we have to, make it so that we are...
Okay, so you said it's department guidance. When will you provide this committee that department guidance that says that the attorney-client privilege prohibits you from giving the information to the OSC? When will I have that on my desk?
So I have already raised the matter with the department's general counsel, and I will work with them to get you...
No, I want a date certain.
Unfortunately, sir, this is not up to me. I am not the...
You're the acting administrator of the TSA. You got 50,000+ employees. You don't have the... You're relying on guidance from the department, and you're going to withhold that information from Congress?
So, sir, to my best of my knowledge, the guidance is not in writing. We are working to get the practice...
You don't have... You just made this up? It's not in writing?
So it is a standard practice...
No, it's not. Mr. Roth, or Ms. Lerner, is this a standard practice?
No, it's not. There is no attorney-client privilege when one government agency is investigating another government agency. It's very much akin to what the IGs do.
Do you see this with any other department or agency or whatever you want to call it?
From time to time, but not to the extent that we're seeing it with TSA.
Mr. Roth, what's your experience with this?
We are part of the Department of Homeland Security, so we get everything, whether it's attorney-client or not.
Ms. Gawadia, I want you to provide the guidance to this office next Friday. Is that fair? A week from tomorrow?
So I will work with the department to get you something by next Friday.
Let me ask you this. What do you think Congress has the right to see? If I ask for all the information, what percentage of the documentation will you give us?
So again, when it comes to attorney-client privilege, I am not in a position to.
Yes, you
opine.
are. You're the acting administrator. I'm asking you right now to provide the information that the OSC has asked for. I want you to provide it to this committee.
So may I offer something? Yesterday, we came visit with Mr. Meadows, and as a part of getting ready for this hearing, this concern has come to my attention in a very strong way. I went back and I asked my staff to do a quick look and see, have we ever had any concern expressed by the OSC to us in the information we have redacted? Has that kept them from proceeding on a case? We found 2 instances. I believe Ms. Lerner has 4 in her statement. I have as of yesterday, if we ever redact a piece of information from the OSC, we will always accompany it with a privilege log. And that will allow OSC to have more information on the information that has been redacted.
Okay, so
That's a
when
starting point.
will you provide the OSC the privilege log? When will you do that?
If I may, that would not be sufficient. It's
Oh,
our
I'm
position
not
that
saying that's an endpoint.
No, a privilege log suggests that there actually is a privilege. It's our position that there is no attorney-client privilege.
But I would
It
like
not be
to-
appropriate.
Your point is well taken, and I concur with it, but I would be interested to see all the different times that the TSA is taking this so-called privilege, which we don't buy into. When will you provide that to the OSC and to the Committee on Oversight and Government Reform? When will I have that on my desk?
The privilege logs?
Yes.
With every document that we issue henceforth, we will issue.
No,
privilege
not in the
logs.
future. I want to know all the ones in the past.
So I am not familiar with how many records.
It doesn't matter how many. I want to know when I'm going to have all of them.
Well, sorry.
You have a week from Friday, okay? A week from Friday, or I'll issue a subpoena. And guess what? I don't need a committee vote. I don't need to go ask a judge. I can do it myself, and I'm telling you here on national television, you will get a subpoena for that information. You should provide it voluntarily. We do not buy into this whole notion that there is any such privilege. Secondly, the information that the OSC is asking for, where they don't have 100% of the documents, when will we as a committee have that?
So again, I would have to take that question for the record because this is a departmental position that I am not unilaterally allowed to circumvent.
Tell me who at the Department of Homeland Security is holding you back?
So I have to work with the Office of General Counsel.
Give me some names. I want to know who to call up here.
The Office of General Counsel.
No.
The General Counsel to the Secretary.
Give me a specific name. That's a big office. There's lots of attorneys. Tell me the attorneys that are telling you not to provide this information to Congress, and tell me the names of the attorneys that are telling you not to provide this to the OSC. I want names.
So I will follow up with you and your
No,
staff.
I want you
after.
right now. You've had notice of this hearing. I need specific names. You had staff sitting there. How many staff are with the TSA?
So
How many staff are with the TSA or in this audience right now? Please raise your hands. Who's paid by the TSA? How many people? Wait a second. 1, 2, 3. Hold them up. 1, 2, 3, 4, 5, 6, 7. One of these 7 people has got to get on the phone, get your butt up out of this committee, and go get that information before this hearing's done. I want to have names, and we're going to call them up there. There is no way. We're going to go to the ends of the earth to protect whistleblowers, and we have this OSC. Ms. Lerner has testified time and time again, we believe in her and her organization. She needs 100% of the information, not some of it, not some that you don't want to have, not the embarrassing. She needs all of it. And I want names of who at the Homeland Security is prohibiting people from giving that information to the OSC.
Mr. Chaffetz, I have asked my staff to step out and obtain permission from the department to give you a name before the hearing is done.
Thank you. And I need to know what information, let me ask you this one conceptual question. I'll turn the time to to the Democrat. What information do you believe should be withheld from Congress?
So I don't believe information should be withheld from Congress unless there are certain provisions, such as the attorney-client privilege, which, again, my hands are tied by departmental policy. I cannot take unilateral action because there are ripple effects across the department. That having been said, I will tell you that when it comes to SSI information, all of this is, we are completely transparent, not just with you, but with the IG, with your staff. They have full privilege to all the information when it comes to SSI and things like that. But when it comes to the attorney-client privilege element, so
I think we've established here that that is so bogus. You're making it up. That may be what the attorneys are telling you. You're a very talented, smart person. Appreciate the work that you do on behalf of the United States of America. But we've got whistleblowers who think they're getting retaliated against. And I want you to stop hiding behind some legalese and throwing attorneys into meetings so you don't have to provide documents. We don't see this problem at this magnitude anywhere else except the TSA, and that's why we're going to get to the bottom of it. I've gone well past my time. We're going to recognize Ms. Lawrence of Michigan for 5 minutes and some more if she needs it.
Thank you, Mr. Chairman. Dr. Gowady, transportation security officers, a front line of employees who protect our airports and our skies, are not covered by many of the civil service protections available to most federal employees. What kind of rights do TSOs have when they are subjected to adverse employment actions?
ma'am, they have full whistleblower protection rights, and they have the ability to bring their concerns before an appellate board to raise some of their concerns.
Who's on the appellate board?
Other TSA employees.
What prevents a TSO from being a subject to an arbitrary personnel action, one taken perhaps because an employee has fallen out of favor with a manager? What protects them?
Ma'am, the entire system protects them. This is all about leadership. We have to make it so that our leadership is well-educated, well-trained, and well-able to make decisions that do not adversely affect an employee on a
I understand that,
because they fall
but
out.
what prevents an employee from getting arbitrary personnel action?
They have the ability to appeal their situation before the appellate board.
Do you agree that fairness and consistency and due process are important components of the personnel system for federal employees?
Absolutely.
Inspector Rob, do arbitrary personnel practices deter whistleblowers from speaking out about security deficiencies?
I believe that it's got a chilling effect anytime there is the threat of some sort of improper personnel practice as a result of making a protected disclosure, for example, of a safety situation or other kind of misconduct on the part of the agency, that there is always that fear that there is a chilling effect that something will happen to that person.
So if TSA employees are reluctant to raise these deficiencies they observe, couldn't this put aviation security at risk?
Well, that's absolutely the case, and we get at DHS something like 20,000 complaints a year from various DHS employees raising exactly those issues. But we do worry, of course, as Ms. Lerner does, that those folks can be retaliated against if, in fact, the word of their cooperation gets out.
I'm going to make a statement now. TSA's arbitrary and inconsistent personnel actions against its employees not only affect morale, but they also create serious risks to aviation security. Every member of Congress is intimately aware of the securities and the responsibilities that are placed on our TSA, and we trust them because we, in our job, must fly back and forth on a regular basis. In TSA, we have a test case of what happens when an agency's employees are excluded from due process protection of Title V. The results are a disaster, and they should never be repeated at any federal agency. To correct what we have seen at TSA, Congress should act now to ensure full civil service protection under Title V are available to all TSA employees, including TSA officers. And also, to my Republican colleagues, when we talk about rolling back federal civil service protections, understand, as we have made a commitment here on this committee to ensure that we protect whistleblowers, when we draw back, as Mr. Roth has said, these protection has a chilling effect. Because if I'm not going to be protected, I'm not going to come forward. With that, I yield back my time.
Thank you. We'll now recognize the ranking member, Mr. Cummings.
Thank you very much. Last week, the committee conducted an interview of former Deputy Administrative TSA Mark Hatfield, and he told the committee that TSA was, quote, governed by self-direction, and, quote, which, quote, bred misbehavior, quote, and led to toxicity rather than a healthy agency, end quote. Mr. Roth, you testified before the committee in November of 2015 about security failures that you uncovered at the time that Mr. Hatfield was serving as Deputy Administrator. You said that an in-depth round of covert testing at TSA found results that you characterize as, quote, disappointing and troubling, end of quote. Do you think that the toxic environment in which self-direction bred misbehavior, as the former Deputy Administrator described, contributed to the security deficiencies you identified?
Certainly what we found, and I think TSA leadership will testify to this as well, or has testified this as well, there was a push to move people through the line and ignore sort of the security aspects of what they were doing. So culturally, there was enormous pressure on the rank and file to just keep the lines moving and not worry as much about security. So I think the answer to your question is yes, we found that sort of culture there that disregarded aviation security.
And so I take it that you found that to be a major problem, huh?
That's correct, yes.
Considering the mission of TSA.
Correct.
So they were probably missing things they should have caught.
Right. I mean, we have issues with TSA across the entire spectrum of what they do, not only at the checkpoint, but how it is that they deal with their own employees, how they deal with airport workers, how it is that they guard the perimeter. The challenges that TSA faces are just enormous. I think it is probably the most difficult job in DHS, which is really saying something, to try to screen 2 million passengers a day, 900,000 different airport employees with a staff of, and then pay attention to a staff of something like 60,000 people. It is an enormous job, and
dealing with the public, trying to get to where they got to go, and I guess many people feeling like they're going through too many changes sometimes.
2 million passengers a day, so just in the course of a 10-minute hearing, that's hundreds and hundreds of people.
Back in 2015, you testified that the most critical task facing TSA was, quote, creating a culture of change within TSA and giving the TSA workforce the ability to identify and address risks without fear of retribution, end of quote. What retribution did you observe at TSA, and why did you believe that the most critical task facing the agency was giving the workforce the ability to identify risks without fear of retribution?
We had seen, and some of this is simply in the public sphere, public media, about instances, for example, as this committee has highlighted with regard to the forced transfers, for example, and the arbitrary nature of demotions and those kinds of things. And we had seen that. And in talking to TSOs and people within TSA, we had gotten the sense that there was a culture of fear and intimidation. I will have to say, with Admiral Neffenger's approach, it was a breath of fresh air that he came in with a different kind of an attitude, not only towards oversight, but how it is that he treated his rank and file. The question I have, of course, is how far down that goes into what is an immense organization, and whether that will continue with new leadership.
This assignment, what do you call it, where they assign people to different places?
It's directed reassignment, I believe.
Where is that now? I mean, what's happening with that? I think he suspended it, right? Is that right?
So the practice has been discontinued. The only time we ask for reassignments is if it is in the interest of security, and we certainly only go to it at the very, very last opportune moment to move people across the country that way. We have put in controls so that these decisions cannot be made unilaterally. Our Office of Human Capital must get into the loop in making the decision. And if a member of the executive service has to be moved, it comes to my desk for signature. And we will definitely look for as many options as possible and only ask an employee to move if it is absolutely in the interest of security.
And so I take it, so that there have been a substantial reduction in, just based on what you just said,
Yes, indeed.
in that type of action. Can you tell us what, I mean, where we went? Did we go from 300 to 5? I mean, what? Can you give me an idea of the reduction?
So I apologize, I do not have exact numbers, but what I can tell you is it has not happened since my tenure at...
Because you agree that that's a very cold thing to do.
Absolutely.
Life is short.
To move people for no reason that is not fully focused to the mission reason, I do not think that is an appropriate practice, and we do not do that at TSA anymore.
Okay. Let me go to you, Doctor. The former deputy administrator said employees got arrows in their backs and were subjected to retribution with regard to personnel practices that made them fearful of bringing up security issues. Does that sound like an environment in which employees are free to identify risks without fear of retribution?
Mr. Cummings, may I please give you one sentence before I go to your... The practices Mr. Hatfield is discussing well before my time, and he's discussing practices even before Administrator Neffinger was in place. I want very much for the workforce at TSA to know the things that ailed them in the past, their leadership today stands behind them and will not tolerate any retaliation for prohibited personnel practices. That is so important because the tone has to be set here. And you ask IG Roth how far it goes down. I make the rounds from the airport level all the way through offices, through cubicles, working very hard to make it so that people see the support they get from their leadership. Also, we are working on leadership training. We want to make it so that the notion of leadership begins on the front line through the TSOs all the way up to leadership, which will help that culture change that you are asking.
Yeah, the culture change, but what I'm concerned about is, I understand what you're trying to do, but how do we put policies in place so that when you leave, this sucks, you may be gone, I don't know when, but my point is, how do you put the things in so that they stay in place?
Absolutely, sir. So I will tell you, we have had outside, the department has come in and looked at our personnel practices and our policies to make it so that we are now more in concert with the department. We have put in checks and balances. But Congressman, the thing that I hope you see is you cannot legislate, you cannot mandate, you cannot you cannot change that by virtue of a piece of paper. It changes by changing the culture. People have to feel appreciated, people have to feel supported. And I give you my word that as long as I'm at TSA, that is my quest.
Well, can you apply to Title V?
So we will certainly work on the Title V notions with you, but I would like very much to undertake a study to see what it would take. But all the privileges afforded by Title V that our staff tell us they want when it comes to in-grade pay increases, et cetera, we can work on that by virtue of policy. And I am working very hard to make it so that we can afford our staff, by virtue of policy, everything that they want.
Ms. Lerner, you described a practice by TSA withholding information that TSA considers attorney-client privileged. You said, and I quote, "When TSA refuses to disclose why it takes an action, it is impossible for SC to investigate whether there was retaliation." Do you believe the TSA's refusal to provide the information you need hinders the agency's ability to create an environment in which employees are free to identify risks without fear of retribution?
Sure. I mean, you need robust enforcement of the law, and the law has no meaning unless it's enforced, and it really hinders our ability to make findings when we're not getting full information from the agency.
Now, Doctor, TSA can have it one way or the other, but not both. Have you asked the Department of Homeland Security about this so-called attorney-client privilege and provide to the OSC all of the information it has requested?
Yes, so we have discussed the matter with General Counsel,
And what did you come up with?
that it is department policy to exert attorney-client privilege in certain instances, a very, very small percentage of the information.
When the chairman was asking you about who we need to talk to, can you tell me who that was, the person you just talked about?
So I did actually, my staff has been able to get us permission to.
Why don't you give it to us now?
Joe Marr, Joseph Marr, Acting General.
Can you spell that, please?
Joseph Maher. He's our Acting General Counsel.
And so he would be the one that we would talk to try to figure out what the roadblock is and why they are withholding information?
Yes, sir.
Show me something. You've known for weeks that this was a deep concern for the committee, and you came here and it seemed like you were unprepared to answer the questions. Help me with that. I mean, you knew we were going to be asking about this, right? And hello, and you know it's a bipartisan effort, and you know we don't want to be hindered with regard to information. I was just wondering why.
So perhaps I miscommunicated. I was not, I fully knew that this was your concern. I just was not aware that Ms. Lerner's staff had any concerns in being able to come to resolution in any particular case.
Okay. Well, you all need to talk then. Ms. Lerner, y'all need to talk. Huh? We can pull Mr. Roth out. Y'all can come together. I mean, come on now. We shouldn't have to bring you all over here just so you can talk. You have telephones? Email?
So we've already decided we're going to start that part.
Good. I'll yield back.
Thank you. I'm going to recognize myself, and then we'll go to Mr. Comer. Let's talk about that relationship with the OSC. What do you believe is your legal obligation to provide documents to the OSC? What is your legal obligation?
So we have a legal obligation to provide documents to OSC.
I find that curious because who is Francine Kerner?
She's Chief Counsel at TSA.
And how long has she been in that role?
So I do believe Ms. Kerner's been there since the start of TSA.
So she was, quote, this is a quote, this is February 21st, okay, of this year. Here's what her quote was when she visited with us. TSA has no legal obligation to turn over documents to OSC, end quote. How is it that she says there's no legal obligation, and you give this committee a letter yesterday that says, quote, TSA recognizes its legal obligation to provide documents to the Office of Special Counsel and does so regularly, end quote. How do you rectify that?
So I was not in the meeting in which Ms. Kerner is alleged to have said that. It is my understanding that she was using that phrase in context to the attorney-client privilege redactions, not in the generality.
Not in the generality. No legal obligation. You say there is a legal obligation. Well, how would you describe your relationship with the OSC?
My personal relationship with the OSC has only just begun, and I can promise you that I will extend to Ms. Lerner an arm of partnership to make it so that if there are differences, they can be resolved.
And how would you, that's your personal one, how would you describe the overall TSA relationship with the OSC?
So it is my understanding that lawyer to lawyer, they do have a very good working relationship. At least that is certainly our side of it. My lawyers have never said that they've had any issue working with OSC.
Who is Steve Colon?
I do believe Steve Colon is presently acting in a different capacity, but he used to be in the Office of Chief Counsel.
He was the Assistant Chief Counsel under Francine Kerner, correct?
Yes, sir.
And he was detailed to head, and this is what's absolutely stunning, he was detailed to head the TSA Office of Professional Responsibility, correct?
Yes, sir.
Let me put up an email that he wrote. I'll read this to you. Jeff, if you can join us, I'd appreciate it. Sorry. I'm done being conciliatory with the OSC. They have been a nightmare to deal with for the employment advice folks. If they want war, they got one, unless the evidence stinks. You can go ahead and put that down. Does that sound like a responsive TSA to the OSC?
No, sir, it does not.
Did you fire him?
Oh, no, sir.
Are you going to fire his butt?
No, sir.
I wouldn't. I'd fire that guy. And you know what? Until you clean house with the legal folks in your agency, you're going to have a lot of problems. That is not the kind of attitude. We're going to go to war with the OSC? You're familiar with the law? You're familiar with the code that comes out of the OPM regulations? You can tell me it's all rosy, but when your chief legal counsel, who's been there since the inception, has saying there's no legal obligation, she is not abiding by the law.
Mr. Chaffetz, please let me leave you with no doubt to the matter. That is unacceptable.
Then what are you going to do about it?
He has, I do believe, already been disciplined, but we will look into it.
And you're going to tell us what that discipline is?
Yes. Please understand, sir, that the counselors that work for us also report through the department, so I have to work this out with the department.
And you know what? You talked about the culture. We get culture reports, and DHS routinely is at the bottom of the heap. I mean, they take the 320 agencies out there, and guess who's at the bottom of the bottom? Homeland Security, TSA, Secret Service. We deal with it, but there's a common denominator, okay? The common denominator is Homeland Security. In order to enrich the culture, you have to have confidence that when something goes awry, there is a fair and honest hearing of that information. And if you have a whistleblower who believes they've been retaliated against, we need a fair arbiter to come in and look at the facts, all of the facts. You're not providing those facts to the OSC. And every employee knows it. They know the deck is stacked against them, and they don't get a fair reading. And you know what? If you want to change that culture, people have to be confident that whether you're at the top of the food chain or the new employee who's just going to work at the TSA, if something goes awry, you're going to get a fair hearing. Doesn't mean we presuppose the conclusion, but when the OSC, the fair independent arbiter here, doesn't get all the information, guess what? You can't look anybody in the eye and tell them that they had their case heard out. Of all those things I just said, what would you disagree with?
So I would not disagree with you that a fair and robust investigation into a person's allegations should be conducted. Just as the whistleblowers have rights, the allegations are made against another employee, and they have rights too. So the due process must go through. We must follow through on the process. I agree with you on that.
Ms. Lerner, your perspective on that?
You know, when we talk about changing the culture, there are a lot of things that an agency can do, but, you know, by cooperating with OSC, by providing these documents, that could really help. You know, I think that there's just some misinformation that may be going on, and we can hopefully clear that up. But, you know, whistleblower protections are key. Other things could help, too. I think the full protections of Title V applying to TSA would be very helpful, so that there's more of a feeling of fairness in employment action so that hiring decisions and promotion decisions are perceived as fairer. But I think first
Okay,
place
so-
to start is where the protections already lie, is with.
I want to recognize Mr. Comer, but I got to go through this. In fact, let me do that and then go through this list of things that I need you all to provide. Let's yield back and let's now recognize Mr. Comer of Kentucky.
Thank you, Mr. Chairman. These questions are for Dr. Gaudia. On May 12, 2016, when TSA's administrator at the time testified before the committee, he was questioned in detail on how he would respond to whistleblower allegations of retaliation, including the improper use of directed reassignments. I will read you several of the statements he made, and I think we may have a slide. Slide 1, I will await the Office of Special Counsel. I think it's important that we look for an independent review of that to determine whether or not there was improper use. And he's talking about of directed reassignments. Slide 2, I'm very interested in the results of the Office of Special Counsel investigation into the existing cases with the individuals who appeared before you. Depending on those findings, I will take immediate action against that. And slide 3, and again he said, depending on what they find, it may point to an appropriate discipline. And my first question, how can TSA tell Congress it will base its responses on OSC's investigations and then refuse to give OSC the documents necessary to complete those investigations?
So it is, in listening to Ms. Lerner, I am beginning to appreciate that she may need more information, which is why we offered to give her the privilege log. Now, I will tell you that to date, we have not received any information that says, at least to the best of my knowledge, information that says the information that has been redacted has interfered with OSC's ability to render a verdict on, I believe it's 46 cases that they have so far taken up for TSA.
My second question, do you agree with the administrator that it's important for OSC to complete an independent review of whistleblower allegations against TSA?
Absolutely.
Okay. Next question. Is there a conflict of interest for Francine Kerner and the Office of Chief Counsel to withhold documents from OSC investigations when multiple whistleblowers who reported retaliation to OSC allege Kerner was involved in the misconduct against them?
So when it comes to the attorney-client privilege information, again, we are bound by that through the department's guidance. So we are not in a position to unilaterally waive that privilege.
One statement here of observation. I'm new, I'm a freshman, and campaigning for the past year, people talk about the swamp and they're frustrated. They're frustrated with Congress, but they're frustrated with bureaucracies that just aren't accountable. And it seems like this committee's been trying for a long time to determine and fix some problems and get some transparency. And in my opinion, it doesn't look like we have that. And I'm looking forward to getting some results and finding out what's going on over there and how we can fix the problem. I yield back my time, Mr. Chairman.
Thank you. We now recognize the ranking member, Mr. Cummings.
I just want to get to the bottom line. Obviously, you're not getting all the information. It sounds like somebody or bodies has not been getting you the information, because if Ms. Lerner needs information to do what she has to do, it sounds like there's some block here somewhere. And I think you need to get to the people in your agency. I mean, I'm just sitting here listening and figure out who's not getting you information. Now maybe I'm assuming too much.
Mr. Cummings, please let me leave you with no doubt in this matter.
Because if it ain't, well, let me, whoa. Before you say anything, it's either you or them.
It's me.
Okay, then you need to explain that.
Yes, sir.
So now you need to tell the chairman why you blocking it. Because now I'm putting it on you. I tried to give you an out, but you didn't take it, so.
Absolutely not, sir. The
Okay.
buck definitely stops at my desk. I take
Okay.
responsibility for decisions made at TSA. Now, when it comes to the attorney-client privilege issue, again, we are not independent.
Right,
We're
you
not
got
unilateral.
lawyers to advise you.
I have to follow the department's
Right,
guidance in
got
this
that.
regard.
Okay.
But I have
But it
opened
sounds
up-
like you didn't know Ms. Lerner, the extent of Ms. Lerner's concerns. That's what I'm getting to. It seems like you didn't, I'm just listening to you. It sounds like you did not know the extent of her concerns.
This is true. I did not.
Now,
And I should-
wait, whoa. I know you want the buck to stop with you. I'm trying to get to whoever is not getting the information to you now. So you just said you didn't know the extent of the problem, but then you said the buck stops with you. Well, what I'm saying is something's happening before it even gets to you, if you don't know the extent of the problem. Does that make sense?
Certainly, sir, but what I can do is I can ask more questions, and I will.
Right, you need to.
And I will.
And what I'm trying to tell you, I'm trying to help you.
Indeed, sir.
Yeah, what I'm trying to tell you is that somebody is not getting you the information that you need, period. Or you would not have, this wouldn't be an issue. I would be, if I were in your shoes and my staff, and I didn't have the information I needed, and I had to walk into a hearing like this and have somebody tell me they have not gotten the information and I don't know it, there's a problem, major problem. You follow me?
Sir.
So I'm just, like I said, I'm just trying to get to the bottom line because, we're just trying to get this stuff resolved and move it on. We got a lot of issues we deal with here. And hopefully we'll be able to get it resolved. When you get back to your office, maybe you can kind of cut through all that, all right? Thank you all.
Thank you, Mr.
I'm
President.
finished.
Thank you. I'll recognize myself, and then we'll recognize Mr. Meadows of North Carolina. Ms. Lerner, does our committee have the full list of concerns or outstanding cases that you need more information from? Do we have that list?
I'm not sure if you have the list, but if you'd like it, we can certainly get it to you.
Let's just confirm that we have the full list of where you have concerns. Ms. Gawadia, I just want to clarify that we do expect the TSA to turn over all information that's been withheld from the OSC, and we expect that to be done by March 10th. That's a week from Friday, okay? That information should be given to both the OSC as well as the Committee on Oversight and Government Reform. So if you're choosing to withhold documents, you're making an election to withhold documents from the OSC, but you're also withholding documents from Congress. And I'm just being really crystal clear here with you. You don't withhold these documents from the Inspector General. So you're being very selective in your application of quote-unquote attorney-client privilege, which we don't recognize. If you don't provide those by March 10th, I will issue a subpoena, and then you'll be on the clock. And then if you don't comply with that subpoena, you will be in contempt. And we will pursue that. And I'm just trying to be crystal clear on the process. You said the buck stops with you. We're going to call on the attorneys, and you can blame it on Homeland, but you are the acting director, and that's the tough spot you take when you're top of the food chain. You also have confirmed to the committee that you will provide logs of the information that's been withheld from the OSC. Again, not recognizing that you have that right, but you're going to provide that information to the OSC as well as this committee also by March 10th, correct?
Sir, we will start providing on a rolling basis
No.
immediately.
No.
So I cannot promise you
How
something.
many people work for you?
60,000.
You're going to provide that.
So 45,000 of them are in the field. We have to appreciate that this may take some time. I do not want to leave you with the fact that I'm trying to stonewall you. I
No,
hope that
you've-
my people back in the shop have already started working the production.
It's
But I
a
cannot
log.
promise
It's a
you.
log. You have tens of thousands of employees at your disposal. I'm just telling you, that's what this committee is going to ask you to do. We've been asking for this for a long time. It should be no surprise. You said you have a log. It shouldn't be that hard to provide.
I did not say we have a log. The offer I made was moving forward, we would always provide a log. You are asking me to go back to, again, a number you don't want to hear, but 50,000 pages to figure out what percentage of that was redacted, and from that, develop a log. We will make our best effort to get it to you by Friday, but if we don't make the full log available for the retroactive instances, we will start producing on a rolling basis, which is something we do with the OSC and something we certainly do with you.
You put anybody that you need on top of that, prioritize the safety of the public, but we're also here to protect the safety of the employees. And so that's the timeline, and that's what I expect from you. I also need the names of any other individuals at Homeland Security who have advised the TSA to withhold or apply the privilege. Agreed?
Yes, sir.
And that too by March 10th. You also have agreed to provide the discipline of Mr. Colon, and that too you can provide by March 10th?
If the discipline has already taken place, I'll have to look at it. I don't know where
I
that
thought you
stands.
said he
sir.
was disciplined.
No, I said he may be in the process of being disciplined. I don't know that he has.
But you'll give us an update regardless.
I will give you an update.
Fair enough. And then you're going to provide the government guidance or advice regarding withholding information from OSC, correct?
I'm sorry, would you say that over?
Provide the departmental guidance or advice regarding withholding information from the OSC.
I will work with the department and get you something on that.
Again, we expect that information by March 10th. Let's now recognize the gentleman from North Carolina, Mr. Meadows.
Thank you, Mr. Chairman. Thank each of you. My apologies. I've had 4 or 5 things going on. Dr. Gawadia, I want to come to you and thank you for the meeting yesterday. And obviously, you've got counsel here, thank her as well. And I guess I'm a little confused because yesterday we talked about a reset. We talked about going forward and really working this, but my staff informed me, and that's why I came back, that we're again trying to insert an attorney-client privilege and keep things from OSC, and I didn't leave with that impression yesterday from our private meeting. Am I misinformed?
Mr. Meadows, I apologize if I left you with the notion that I could do something without the department's guidance. I still have to follow the department's guidance. What I offer to you is...
So are you saying that the Secretary of DHS concurs with that? Because I'll call him.
No, sir, I'm not speaking for the Secretary at all.
So then what is... I was very clear yesterday. In fact, in ways, I was a little bit more blunt than I wanted to be, and acknowledged that to your counsel that was there. And yet, I thought the agreements that we had yesterday coming out of that meeting, and it sounds like you're walking them back now, Dr. Guadia, are you not?
No, sir, I don't believe I am. I believe you mentioned that you did not think it was appropriate.
Well, and you agreed that you would give the documents to OSC unredacted.
No, sir, I do not believe I did that, and if I left you with that impression, I
Well, I
deeply
should have had a
apologize.
stenographer there. And then, I mean, Dr. Guadia, let me just tell you, I told you I would give you grace. And I'm willing to. I'm willing to say that there's been a lot of mistakes that have been made here, but what I will not do is have a pre-meeting that went really well and then have you, after you went back and apparently talked to somebody, and come in here today and suggest that it's not okay.
Mr. Meadows, again, I sincerely apologize if I left you with the impression that I could give away the attorney.
Who can?
It has to come to us, guidance through the department, the general counsel of the department.
All right, so I asked you yesterday for what statute. You said there wasn't a statute. All right, so I asked you for what rules or regs, and you said it was department guidance. I understand that you don't have that written. Is that correct?
Not to my knowledge, sir.
All right, so if you don't have written guidance, who the heck gave it to you?
So the attorneys at...
Who told you that you have guidance?
The general counsel, the acting
All
general.
right, so the very person that I've had concerns with, that I expressed to you
No.
yesterday,
No,
general
sir.
counsel for who?
General counsel for the department, sir.
For the Department of Homeland Security or
Yes, sir.
TSA?
Department of Homeland Security.
So the general counsel, between yesterday and today,
No, not between yesterday and today. Again, going back to yesterday.
so when did you talk to the general counsel about this guidance?
So well before our meeting yesterday, which is why I am a little shocked that.
Okay,
that I
so
left
maybe
you-
I misunderstood you. So let me ask you this. How can we believe the general guidance of verbal communication from your general counsel? How can Congress look at that?
So
Do you not see a problem with that?
I do, sir, and this is why I am
All right,
committed
so-
to working with the department to get.
So let me
you
just
something.
tell you, if you will comply, I don't recognize the attorney-client privilege, and you know that I don't.
Yes, sir, that was clear yesterday.
That was clear. The other part of that, the chairman doesn't recognize it, neither does the ranking member recognize it.
Yes, sir, that is.
All we want is to make sure that Ms. Lerner can get her job done and not be stonewalled. And I told you yesterday that I was willing to have a reset. But today's testimony is very, very troubling, because it sounds like that we had a nice kumbaya kind of meeting, and then all of a sudden we're here today with entrenched rhetoric coming from the general counsel. Is that not it?
No, Mr. Meadows. Again, I deeply appreciate the time you took to visit with me yesterday. And when
No,
we
I
discussed-
appreciate your time. Let me just say this. It needs to be productive time, though.
Absolutely, and one of the promises I made to you yesterday was I would reach out to Ms. Kerner. That's the
Okay,
first
but
thing I
you're
did
saying
today.
that the things you redacted won't interfere with her investigation.
And I went back.
That's your sworn testimony.
I went back, in fact, as part of my testimony, I recounted something I said to you yesterday, that it was, to the best of my knowledge at that point, that nothing had
You
interfered.
used a little qualifier,
No.
to the best of your knowledge.
And so when I went back from our meeting, I asked my staff to go through all their emails and determine that that was factual.
Okay,
When they came back with two,
right.
at that moment, I said to them, from now on, policy is if you ever redact anything, you will provide the OSC with a privilege log.
All right, so let me ask you this. Has the OSC ever disclosed things that were not appropriate to your knowledge?
No, sir, not to my knowledge.
Well, then why do you redact it then? If they've never had a problem, why do you redact it?
So there are multiple parties, as we discussed, in an ongoing case.
But if
that are-
they've never released any of that, why are you concerned? Let me tell you why you're concerned. You're trying to cover up for something that may or may not have been done. And I told you I would reset. But at the same time, if you're not going to reset and give her what she needs, we will look at this with the chairman's indulgence. We will look at this. We will ask for subpoenas. We will make sure that we get the information. I am not going to be stonewalled.
So it is absolutely not my intent to stonewall you, and I do appreciate that we have a reset in our ability to share information and be absolutely transparent. But I do appreciate that there are certain attorney-client privilege issues that
No,
we
I
have
don't
to-
appreciate that.
I do. I have to work with the department.
Okay.
I
so
promise you,
should
I will take it back.
Should
to
I
the
call
department.
General Kelly?
Please don't do that until I've.
Well, let me just tell you, you got a short fuse, because I can't imagine that General Kelly would like to cover up anything.
Oh, sir, please, I hope you cannot imagine that I would want to cover up anything.
Well, that's how it appears, Dr. Guada. That's what I'm saying. Just get Ms. Lerner what she needs, okay? I'll yield back.
Thank you, gentlemen. Ms. Gawadia, if the Homeland Security guidance violates federal law, which one are you going to follow?
Federal law, sir.
Mr. Roth, what information is TSA not providing you?
Nothing. They're completely cooperative.
Do you give everything to Homeland Security's Inspector General?
Yes, sir, we do.
Do you give everything to the OSC?
Other than the attorney-client privilege redacted information, yes, sir, we do.
So why don't you recognize your so-called made-up attorney-client privilege? Why isn't that true with the Inspector General?
So they are part of the department. The guidance applies external to the department.
External to the department. You're all part of the United States government, correct?
We all are, sir.
Who do you work for?
The American public.
That's right. That's right. That's who's paying. And part of what we did is we set up a statute, law, federal law, that you said you were going to abide by, that allows the Office of Special Counsel to dive into these issues. So you do treat the Inspector General different than you do the OSC.
In this instance, yes, we do.
Do we have any problems with that, Ms. Lerner?
Yeah, let me just say, we do get SSI information, we get sensitive security information from TSA. We never had a problem getting that. We handle it appropriately. They can mark it as sensitive. I'm confused about why they don't provide us with what they consider to be attorney-client. We can handle that information the same way we handle the SSI information. If they want to mark something as privileged, we'll make sure it's handled in a confidential way. We're not going to release it
no,
without talking to them. I think
You have
we
a
can
solid
address
reputation.
any.
You don't have to convince us that you have the right reputation. And we set it up so that you could be the one to be the independent arbiter here. Ms. Gawadia, is the White House external to the department?
Yes, yes, they are, sir. But I don't know, if the next
Really?
question is, do you share it with the White House? I don't know the answer to that. I'll have to take that for the record.
Yeah, it's just the logic here is just, it doesn't make sense. It's just kind of comical, and that's the problem. And you're unique. You're an outlier.
The department, sir, this guidance applies not just to TSA,
Yeah, no,
but to all
I think
components.
I think you're a very nice person. You have a host of issues that you have to deal with. I think the guidance here that you're getting is wrong. I think it violates federal law. I think it's unacceptable, and it's something that now has the full attention of this committee, I assure you. And we were going to go to the ends of the earth and really, at the ultimate, what we're trying to do, both sides out, we're trying to protect whistleblowers so they get a fair hearing. But you know what? They can't get a fair hearing if the OSC only gets a portion of the documentation, even though the law says they get all of the information, and they are set up to do this. They are authorized by Congress. They do work for the American people. We do appropriate money, even though some would like more money. That's the problem and the challenge. And there is a conflict when that attorney may or may not have been involved in some of those decisions in covering that up. I think you do have a cultural problem with the attorneys as well, both at TSA and at Homeland Security, as was demonstrated by the email. And I am very curious to see what the discipline was for that sort of attitude and approach. And I find it wholly unacceptable. I do appreciate everybody who was here and sharing testimony today. We look forward to following it up. And the committee now stands adjourned.